Hi everyone. In this class, let us discuss all the essential elements of a valid contract. So this is very important question from the final examination point of view. Let us go into the discussion now. Here first we have to discuss what is contract. So contract means it is nothing but an agreement as well as it should be enforceable by law. Agreement means there should be an offer as well as acceptance. One person has to offer, the other party has to accept. Then we have to call it as agreement. Contract means it is not only an agreement, that agreement must be enforceable by law. Then only we call it as contract. So here according to Indian Contract Act 1872, so there is a definition for contract, and this definition is mentioned under section 2 and subsection H. So contract means an agreement enforceable by law. So whenever any agreement is enforceable by law, then we call it as contract. That is the meaning of that contract definition, which is defined under section 2H of Indian Contract Act 1872. Here I have given that contract is equal to agreement plus enforceable by law. So it is contract means it is a combination of agreement as well as enforceable by law. Hope this is clear for everyone. And let us go to all essential elements of a valid contract. If any agreement we want to enforce it by law, then that agreement must possess some essential elements of a valid contract. Otherwise, it is not enforceable by law. So, all these essential elements of a valid contract are mentioned under section 10 of the Indian Contract Act 1872. And let us discuss all those essential elements now. If any contract, if you want to call it as valid contract, then it must possess all these essential elements. Then only it becomes a valid contract. Otherwise, that contract will become void contract. Let us go to the discussion. First essential element is offer and acceptance. So offer means if one person want to do something, then he has to tell about his opinion, or he has to propose for that to another person. Then we call it as offer. So one person makes the offer to another person. That other person to whom the offer is made must accept it in a lawful manner. Then only we call it as valid offer as well as valid acceptance. If we want to create a valid contract, there must be lawful offer by one party as well as there must be lawful acceptance from the side of other party. So here offer should be there and acceptance should be there, but both should be in a lawful manner. So lawful means what? Lawful offer and acceptance means it must comply with the rules that are laid down in Indian Contract Act 1872. So whatever rules are given for offer as well as acceptance, so the offer whenever that is made, that must possess all these rules which are laid down for offer as well as acceptance according to Indian Contract Act 1872. Then those offers as well as acceptance will become lawful. If lawful offer and acceptance is there in any contract, then that contract will become valid contract. So here if you observe, I have given pics here. So sale of up to 50% off. This is offer made by one either company or any showroom, and here acceptance from the side of public, anyone can accept that. So if both are lawful, then only it becomes a valid contract. Hope this is clear for everyone. Let us move to next one. Second one is intention to create legal relationship. So if you want to call any contract as a valid contract, it must possess the second element also. So from the side of both the parties, they have to create and they must have intention to create a legal relationship. Then only it becomes a valid contract. So here, if there is no such intention on the part of the parties, then there is no contract. So that contract must have an intention from the side of both the parties to create a legal relationship. Okay, then only it becomes a valid contract. Otherwise, there is no contract in between those two parties. So, how to create legal relationship? Agreements of social and domestic nature do not create a legal relationship. They do not contemplate legal relationship. Okay, agreements of social as well as domestic nature do not create a legal relationship. So these social agreements as well as domestic nature agreements will never become the valid contracts. So let us take one example here. There is an agreement in between two friends that one friend offered another friend to come for lunch. He invited, first person invited. Okay, so there is an agreement to have lunch at friend's house. So here this agreement is not intended to create any legal relationship, and this is a social agreement. So this will not become a valid contract. If one person is inviting other person or friend for lunch, okay, this will never become the valid contract, because this is a social agreement. Social agreements, domestic nature agreements will never become the contracts. And agreements between wife and husband also are not intended to create legal relationship. So if any agreements are done in between wife and husband, suppose wife is asking husband, please take me to shopping mall, I want to purchase something. Husband is unable to take her. Then wife can't file any case on husband, because this is the agreement in between wife and husband. So these are domestic nature and social agreements. So these agreements will never become valid contracts. Hope this is clear for everyone. Let us discuss one case here. So this is very popular case, Balfour versus Balfour. So Mr. Balfour, he is a husband and he was employed in Ceylon, and Mrs. Balfour, owing to ill health, actually she is not well. So whenever Mr. Balfour actually has to go to another country, and Mrs. Balfour is not well, and she had to stay in England only, and she did not go along with her husband. So she stayed in England and could not accompany him in Ceylon. So Mr. Balfour husband promised to send her Here Mr. Balfour promised to send her 30 pounds per month. Here husband has gone to Ceylon and Mrs. Balfour stayed in England. So Mr. Balfour promised his wife that he will send every month 30 pounds while he was abroad. But Mr. Balfour failed to pay that amount. So what Mrs. Balfour did, she filed a case against her husband for recovering that amount. So the court held that it was a domestic agreement, and this agreement was not intended to create a legal relationship, so it is not a valid contract, so that is not enforceable by law. So judgment came in favor of Mr. Balfour, and here Mrs. Balfour cannot recover that money from her husband because it is a social and domestic agreement. Hope this is clear for everyone. Let us go to next point. So third one is lawful consideration. First of all, you must know what is consideration. Consideration means something in return. If one person is doing something, the other person will give some other thing. So there should be some benefit from the side of both the parties. For example, if we go to one shopping mall, we purchased one item. So we are receiving the item and we are paying cash. So item is consideration for us and cash is consideration for the seller. So here both parties should get benefit out of the contract. So something in return is called consideration, and consideration is also known as quid pro quo. So consideration is an essential element for a valid contract. If consideration is not there in any contract, that is not a valid contract. That becomes a void contract. Any agreement without consideration is void. So consideration is a price for which the promise of another is brought. Consideration may be in any form. It may be in the form of money, or it may be in the form of goods, or it may be in the form of services also. Suppose for example, if one patient is there, he is suffering from some ill health, he went to one hospital, he went to doctor. So he is paying money, and what doctor is doing, he is rendering services to the patient. So here services is a consideration. Hope this is clear for everyone. Okay, so consideration may be in any form. It may be in the form of money, it may be in the form of goods, it may be in the form of services, but consideration should be there in every contract, and that too lawful consideration. So then only we call it as valid contract. No consideration, no contract. Remember that point. Okay, so here you can see the example pic. Seller is rendering some services to the buyer and buyer is paying cash. So here service is a consideration, cash also is a consideration. Okay, service is consideration from one side party. Next, cash is a consideration from the side of the other party. Let us go to next point. Next one is capacity of parties. According to section 11 of the Indian Contract Act 1872. So the parties to an agreement must be competent to a contract. There will be two parties in the contract, and those contract must have capacity to enter into the contracts. If they don't have capacity to enter into the contract, they should not make the contract. if they make any contract, even they are not competent to contract, then the contract become void. That will never become a valid contract. So the parties, whoever are entering into the contract, they must have some eligibility criteria. So they must be eligible to enter into the contract. They must be competent to contract. Then only they can enter into the contract. So we may get a doubt. Who are eligible then to enter into the contract, and who are not eligible to enter into the contract? I have given list here. So the following persons are competent to enter into contract. Who are eligible to enter into contract? Who are competent to enter into the contract? Majors. Majors means the person who has attained the age of 18 years. Who is above the age of 18 years, they are called majors. So majors are eligible to enter into the contract. And second one is persons of sound mind. So sound mind means they must be capable of understanding everything. Then we call them as sound mind persons. So here mad persons means insane persons, they are not coming under sound mind category. Okay, so persons of sound mind, whoever are not insane persons, not mad people. Okay, so these will become the persons of sound mind. And third one is persons who are not disqualified by law. So Indian Contract Act and any other law, any other act says that these people are disqualified to enter into the contract, then those people are not eligible to enter into the contract. So the persons who are not disqualified by any law, they are eligible. Okay, so if the persons who are not disqualified by law, they are eligible to enter into the contract. So majors, persons of sound mind, persons who are not disqualified by law, these three people are eligible to enter into the contract. Then we must know who are incompetent to contract, who are not eligible to enter into the contract. Minors. Minors means the people who did not attain the age of 18 years. Less than 18 years people are known as minors. So those are not eligible to enter into the contract. Minors are not eligible to make any contract. Second one is persons of unsound mind. Here I have given pictures. Okay, so unsound mind means mad persons, insane people, and here the one who have taken alcohol also, he also is treated as unsound mind person only till he comes to the normal stage. Okay, so whenever any person after taking alcohol, if he makes any contract, that is not valid. Okay, so because that person also is treated as unsound mind person till he becomes until he comes to the normal stage. Okay, and next persons who are disqualified by law. So if law disqualifies any person, then that person also is not eligible to enter into the contract. These three people, minors, persons of unsound mind, persons who are disqualified by law, these three are incompetent to contract, not eligible to enter into the contract. Then who are eligible to enter into the contract? You can see there, majors, persons of sound mind, and third one is persons who are not disqualified by law. Okay, otherwise you can also say that persons who are qualified by law. Is it clear students, this capacity of parties? Hope this is clear to everyone. Let us go to next point. Fifth one is free consent. Consent means giving acceptance. Okay, free consent means acceptance should be given freely. If one person is making an offer, the other party has to accept. So he has to give his acceptance. That should be given freely. Freely means without any force. Okay, force should not be there. So free, that is known as free consent. So here, according to Indian Contract Act 1872, section 13 gives the definition of free consent. Consent means parties have to agree upon same thing in the same sense. So both the parties in the agreement must agree the rules as well as the contract in the same sense, in the same thing. Okay, so what is this? Suppose one party is making an offer, the other party is accepting, but here what is the point? Free consent means the other party has to accept freely, as well as both the parties have to agree upon same thing in the same sense. Okay, let us discuss by discussing one example, that point. And this free consent also is known as consens ad aidem in English law. So remember this word, consens ad aidem. Okay, so free consent is called as per English law in this way, consens ad aidem. Okay, so let us take the example to discuss free consent. A is having 2 cars. He is owner of 2 cars. He owns 2 cars. One is Maruti and the other one is Sandro car. And A is offering to sell B 1 car. Okay, he is having 2 cars and he is offering to B that he is informing B that I want to sell my car, 1 car. A intended to sell Maruti car. So what is the intention of A? He wants to sell Maruti car, but B accepts that offer thinking that it is the Sandro. So what B is doing? He is thinking that, oh, A is going to sell Sandro because he is having 2 cars, Maruti and Sandro. A is intended to sell only Maruti car, but B is thinking that A is going to sell Sandro car to him. So there is no clear information in between these 2 parties. Okay, they are not agreeing upon same thing in the same sense. Okay, so there is no consens ad aidem. Hence, no contract, because they are not agreeing upon same thing in the same sense. Okay, one party is thinking that it is a Maruti car. The other party is accepting that it is a Sandro car. Okay, here there is no free consent. Okay, so because consent should be given freely. Okay, and as well as they must agree upon same thing in the same sense, then only we call it as free consent. Okay, and according to section 13, consent is said to be free. Okay, if you want to say to anyone that okay, that is free consent, then we can confirm that it is a free consent when it is not caused by the following. What are those following? One is coercion, second one is undue influence, third one is fraud, fourth one is misrepresentation, fifth one is mistake. If these 5 are not there in any consent, then we call it as free consent. If any one is there in the consent, then definitely we can call it that as there is no free consent in the contract. Okay, the contract or the consent should not be caused by any one of the following 5. If coercion is there in any consent, it is not a free consent. If undue influence is there in any consent, it is also not a free consent. If fraud is there in the consent, not a free consent. Misrepresentation, mistake is there in any consent, then that also is not a free consent. Okay, so what is coercion, undue influence, all this you will understand at the time of discussing other topic separately. So now this information is enough here. Hope you understood this. Now let us go to next point. Sixth one is lawful object. So the object of an agreement must be lawful, and if it is not lawful, it is not a valid contract. Whenever the object of the agreement is lawful, then only the contract becomes valid. So when we can say that the agreement, the object is not lawful, it is unlawful, whenever, you can observe the points here, whenever it is forbidden by law, and it is of such nature that if permitted, it would defeat the provisions of law. Third one is it is fraudulent one. Fourth one is it injures an injury to the person or property of any other. Fifth one is the court regards it as immoral or opposed to the public policy. So object means if one party is offering, whatever he is offering, or whatever he wants the other party to do, that act. Okay, so that is known as object. If suppose one seller is selling gold to another person, gold is a object here, selling activity is a object here. Okay, so if one person is offering the other party to murder the another person, so that is not a legal one. Okay, that is immoral and opposed to public policy, and that is illegal actually. So the object is unlawful, then the contract will never become a valid contract. Okay, if one party is offering anything to another party, if another party is accepting that one, then that act will become a fraudulent act, or it is not, it is forbidden by law. Okay, and it is going to defeat the provisions of law, then we will call that as a unlawful object. Okay, always the object of the contract must be lawful, then only it will become a valid contract. Hope this is clear. Let us move to next point. And next, seventh one is certainty. Here, according to section 29 of Indian Contract Act, agreements made in between two parties must be certain. Agreements that are not certain are void. The terms of the contract must be certain. Certain means what here? Here, one party wants to offer something to another party is going to accept that, then there is an agreement. If offer and acceptance is there in anywhere, then we can call it as agreement. Then that agreement must be certain in between two parties. Certain means it should be clear, and one party has to give clear offer to do or not to do anything to another person. So it should be a certain. Okay, here if you go to one seller is offering garments to the buyer. So here garments, he is going to sell those particular garments. So here certainty is there. Okay, it is clear. Then we can say that certainty is there in the agreement, because the other party, whoever is going to purchase, he will pay cash immediately. So certainty is there. Then we can call it as a valid contract. If the agreements are not certain, then it will become void. Let us go to next point. Possibility of performance. The agreements whatever are made in between two parties must be possible to perform. If there is any impossibility to perform those agreements, then those are not enforceable by law. Okay, and we can treat them as a void contracts. They won't become a valid contracts. Okay, so there should be possibility to perform those contracts, then only it will become valid contracts. Okay, here I have given one example. Mr. A agrees to discover a treasure by magic. Such agreements are not enforceable because here magic, by using magic skills, he can't discover treasure. So this we know. So that is why there is no possibility to discover the treasure by magic. Here impossibility exists. So it will not become a valid contract. Because those agreements, discovering treasure by magic, we can't enforce it. Okay, we can't enforce it. That is why those will become void contracts. Next, ninth one, not declared to be void or illegal. The agreements or contract which is made, it should not be declared to be void or illegal by any law. If law declares that those agreements are void, then definitely those agreements will become void. If law says that those contracts or agreements are illegal, those becomes illegal and those will never become valid contracts. So void agreements, illegal agreements never become valid contracts. Okay, so next one, legal formalities. All the legal formalities should be followed to become a valid contract. So whatever rules and regulations are laid down in Indian Contract Act, those all should be followed at the time of making the contract. All legal formalities should be followed. Then only it becomes a valid contract. If legal formalities are not followed, those contracts becomes void. So an oral contract is also valid. So here I have written VALIS, that is D. Instead of S you can write D. Okay, oral contracts also are valid, but written contracts, written agreements are best agreements because that will work as a evidence in the future. And in cases of some contracts, compulsorily they have to make the agreements in writing only, and registration also is required. Hope this is clear for everyone. These all are essential elements of a valid contract. So if you have any doubt, you can comment in the comment section, so that I will be knowing what are your doubts and I may clear your doubts also. So go through this video completely, and whatever I explained as well as whatever here I have written, all these are very important, and you can follow these notes also, so that it will be useful from the examination point of view. Hope this is clear for everyone. Please like, share and subscribe the video. Thank you.